It's an unfair comment because to make a bail matter and say one proposal, other proposal, it's a bail matter. I'm not allowed to open my merits on bail for 3 minutes with these kind of interventions. These are only delaying tactics every time. Point number one, this man was 62 years old, is in jail from 4/5/25.
26 notices were given, 7 he appeared, 90 he did not appear.
Wait, please, my lords. Well, it's I have a proposal, I'll come to it, but Manoj, my merits are never even, give me just 3 or 4 minutes to give the merit, then I'll come to the proposal immediately. Just take this sheet, kindly give this. Kindly
I had one request, let's.
Now,
I just request, let's. I had one request, let's. Your lordship, I had one request. Lordships had asked them for some proposals so far as the settling the home buyers are concerned. Plus, they did not disclose in their petition that your lordships has already seized of the matter. Mr. Jain was appointed an amicus, is daily looking into it. The very least they could have done is before saying what they are now doing is nicely giving one proposal here, using that to get rid of us and the other.
Can I just?
Mr. Jain is here from his office, somebody is here.
We are arguing. Well, it's
But at least they could have disclosed that.
Their companies are also among those where we have.
Because Mr. Jain is actively, my intervention is there. I am not concerned with the bail. But technically an intervention shouldn't have been filed. But the fact that he is trying to get around Mr. Jain's investigation and the progress made in that matter without even disclosing that to your lordships, let's kindly ask them to show in the writ petition where they have disclosed that order where your lordships have issued notice and appointed Mr. Jain as amicus. They are there.
Krishna, may I be allowed to start, Pals? It's an unfair comment because to make a bail matter and say one proposal, other proposal, this is a bail matter. I'm not allowed to open my merits on bail for 3 minutes with these kind of interventions. As if your lordship doesn't know, lordship is handling the other matter. Where is that suppression? Your lordship is charged with that matter. I've been bearing the other matter also. Now just give me 3 or 4 minutes on the bail. Then I'll come to the proposal also. These are only delaying tactics every time. Point number one, this man was 62 years old, is in jail from 4/5/25 on normative issues of law, Malas.
How old? 62 years.
62, it's technically a senior citizen. I know a lot of smile. We have Malas longevity today and may God give us all 90 years, but it is declared for benefits as senior citizen. If you go to a card, your lordship gets a senior citizenship advantage. But Malas, this man is in jail for 1.25 years on normal normative principles of bail. Please consider what your lordship says. Point one. Point two, just take this note. I'll just take 3 or 4 minutes on this. Just take this note. It's 2 pages. I won't read all of it. Every time it happens, my learned friends take it down the path of proposals and counter proposals. So the bail must await an amicus resolution in a report. Now, Malas, I'll be very quick. He has 2 sons, Malas, Sikandar, second para, allegedly the principal accused. He was arrested, 9 months in custody and is on regular bail. Page is given, 651. His other son is very interesting, Malas, Vikas Chokar, said to be non-cooperative, called many times. Then they go to the court and make a statement that we do not want to arrest him. That is Malas, page 1354. I forgive my lords, I'll not take the pages, kindly forgive me. I'm just making the point. I am not named as an accused in the initial schedule offence in FIR 11. This forms the basis of the ECIR. Even other FIR 11, that is Malas, in this, even in 11 FIR, that is 11 of 21, it ceases to exist as the complainant has withdrawn his complaint at page 313 at 350. Then comes a subsequent FIR merged by department Malas in existing ECIR. The agency in FIR 175 categorically records that the petitioner has no role to play and is found innocent. That's like a closure challan. Well, kindly consider 1.25 years, 62 years old. Core allegation. Well, I will satisfy my lords on the proposal in a minute. I am not running away. And my learned friends have given a laughable counter proposal. Just give me 2 or 3 minutes more. I'll come to that. Core allegation in the surviving predicate offence, which is 175, is the submission of forged bank guarantees. Subsequently, the said bank guarantees are substituted with fresh bank guarantees and other securities, which are duly accepted by the concerned statutory authority. Consequently, the Director of Town Planning, by order dated 27th of July, withdrew the blacklisting orders and revived the licenses. Then, Malas, 6. Landowner FIR is a third set, Malas, 151 and 152. They are entirely civil disputes, Malas, entirely. they have allegedly, Malas, the FIR is registered to pressurize prepayment from home buyers. Investigation remain pending. Now, Malas, forget this para 7, 8, etc. Come to Malas, para 11 to save time, Malas. DOE has already provisionally attached properties and assets. Vide the Malas provisional order, the numbers are given. The entire proceeds of crime, including any value, is therefore fully secured. Fully secured. Then, Malas, prosecution complaint is filed in June 24 against 3 individuals. 2 companies relying upon 31 witnesses, 154 documents, several thousand pages. Supplementary prosecution complaint has been filed against the present petitioner on 1 July. Implicating, that's when I come in first time. Implicating 6 individuals and 3 companies. So and so witnesses, numbers are given, have been cited. 302 documents, 4,000 pages. 53 witnesses. Malas, is this fair to keep a person like this? Initial FIR which formed the basis of PMLA stand closed, whereas in other FIRs that are sought to be subsequently subsumed, the investigations are yet inchoate. Then, Malas, I will skip this, only 15, and then I'll say something else, and then I'll come to proposal in a minute. Trial is at a nascent stage. Cognizance is on January 26, etc. I have appeared in para 16 on 7 dates. In para 16, I have given 7 dates. Second note. Just a bit. I have appeared on 7 dates in para 16. I am not a flight risk. One set of dates, come on now, don't. Well, it's page of one single page of dates I told you. Where is it?
The 26 dates that I got them.
Well, it's one set of dates, 1 page only, and then I'll come to the proposal. Oh, sorry, my apologies, sorry. Kindly give this. Give it to them. This is what happens with this person, Malas, and still the Malas ED, etc., and the DOE. This is only 1 page. On 4th of May, this man is Malas, his son is suffered and is out. The second son, they make a statement in court, I don't want to arrest. This father is inside for 1.25 years. Petitioner is apprehended by DOE official Shangri-La Hotel, during which he was physically assaulted, leading to fracture. CCTV shows this. Just give me a minute, but only 1 page. Instead of providing him with immediate medical treatment, he is taken to the ED central office, then to Gurugram office. He is formally arrested with a arrest order, provided a copy to reasons to believe and grounds of arrest. Duly records his protest. Then after 7 hours, he is taken to Civil Hospital, Gurgaon. Well, the timings are given. That is at 9:20, 12:10, 2:37 a.m. and 5:15 a.m. Gist of incident: person brought by ED for medical examination around 5:15. Person giving list of injuries, history of injury while arresting by ED officers. The history gives is reddish bruise present over so and so. Is on treatment. Advised ortho opinion within 12 hours. See the ortho opinion. Kind of weapon used, blunt. Petitioner produced before special court, where now see Malas, item 6. While remanding to the civil hospital, Malas, the court issued directions, wherein through medical examination, X-ray confirmed fracture to his left elbow, immediate surgery and ORIF fixation. Fracture. Now, Malas, despite all this, I have served Malas. Now, a proposal. Just come to 2 pages and I am done, Malas. One is my proposal, which was also mentioned before my Lord Justice Bakshi sitting in the vacation bench. And then I'll come to the ED's last. There are only 2 things and I'm done, Malas. First, come to my proposal. Give 18th of June, my affidavit, counter affidavit. Well, this is, I submit an unexceptionable proposal. There is no chicanery in this. This is the way to solve the problem. But your Lordship will just have a look at it. Just kindly turn to the affidavit. Well, have your Lordship got the affidavit? It's in June.
Yes.
Yes. Well, just come to page 4 straight away to save time. Well, at page 2 bottom are the 3 projects. My Lord knows the names: Mahira 68, Mahira 103 and Mahira 104. Now, let's kindly come to page 4. The order records that I will place, forget that, come to the lower part, last part of page 4. For Mahira 68 and 103, the amount of 363 crores and 163 crores received from home buyers for Mahira 68 and 103 is alleged to be proceeds of crime. for completing the said two stalled projects and handing over possession of flats to the respective home buyers with registered sale deeds, petitioner's son, the deponent here, has produced Sheetal Impex Private Limited, because we want to show our bona fides with the money. A RBI registered NBC, and I believe they are represented through council also. Are they here? I don't know. Last time they were there. Which had agreed to infuse the funds required by Mahira for construction and completion of both projects against unencumbered security of the subject project assets, receivables, and other attached assets of Mahira Group and personal guarantee. Skip some pages and come to the lower part, fellows. Likely to exceed the funds required for completion even on conservative basis. In 68, the receivables and unsold inventory is 151 crores. So obviously I will sell it, the money will come, fellows. 151 is not giving free. While the estimated balance construction cost is 104 crores. In 103, the receivable is 134 crores, while the balance construction cost is 100 crores. So I have the inventory. The timeline for completion of the two projects and registration of sale would be varying between 3 to 20 months. From commencement of work, I will produce Sheetal Impex, who's here in court, I am told. This is upfront. Now come to Mahira Home 68 at page 6. The number of units, etc. is given. Residential is 1497, commercial is 76, saleable car parking is 910, given for all the three right up to the bottom of page 7. I will skip all this. Come to page 8 now. Timelines, photographs. The structural work, now this one is for which Mahira is this? Tower A to 68. 68. This tower A to G is 68. The structural work, including installation of lift, is over. The remaining work I am undertaking to the court from when the court allows 3 to 6 months. I am not able to run away, Malas. I have said register sale deeds. I can't do more, Malas. I cannot do it without selling the inventory and allow it to completing. Then, Malas, next one below that. Tower H2N 697 apartment. This is phase 2, Malas. Structural work not complete. I am undertaking to the court 12 to 16 months. 12 to 16 months. It's a bona fide attempt.
I'm saying my proposal.
Hon'ble, try to go to the good reason should be kept inside at least. We will do something.
High Court.
High Court.
I told you I can do nothing. I will leave after I finish, till then to pass over. You don't realize two matters I'm putting first. Apart from missing the mentioning outside.
That's what we do, sir.
Just follow 3 or 4 minutes more. Now come to the middle of page 10. Your Lordship had a committee, Malas, middle of page 10. Committee is constituted, middle of page 10, constituting SDO, Divisional Magistrate, District Town Planner, etc., etc., to submit the report, and the said committee, upon physical examination inspection, supported by photos, found that in Mahira Home 68, Malas, out of so-and-so flats, approximately 80 to 85% were complete. Then, Malas, I give all the details upfront in a chart in the next page 11, and I give the photos in 12. And at the end of 30, at the top of 13, I say, Malas, for this third project, I will take 18 to 20 months to register the sale deeds. That is at page 13 top. And lastly, Malas, 104. Now, this is, yes, this is important, my lords. I think in the vacation noted this also. Third line at page 13, at para 15. It is proposed to seek permission of the Honorable Court to deposit the entire amount of 90 crores received from the home buyers. However, this condition, Malas, led to some reaction from them. It has to be the condition, kindly see. The same deposit by me of 90 crores would be subject to the lifting of attachment of the project land to enable the execution of a suitable definitive tripartite agreement. Malas, how do I construct except the land?
There is no bar. Refund everything. Usually it's land owner's land.
Around the world.
But attachment, I mean, attachment means creation.
Between land is not yours. Land is not yours. The money I've taken is 90, I will give it back. This is a construction on the land. It's an agreement between me and the landowner. I can't construct unless that is lifted. How do I use that land? And and I will refund the full money. That ends. Now one para in their reply and then I will close. Mr. ED files a counter affidavit a few days ago. What is the date?
Not counter, it's a reply to your.
Very well. That's a counter. That's also called a counter of some sort. Come to para 48 of that, their reply. Just see. I use the word laughable. I mean no disrespect, but I don't understand how this works. And I think I'm right in saying this part of the proposal is laughable. Kindly see.
Which one?
Page 16. I may be wrong, certainly. No, not 16. It is 21. Step 1, step
21.
21?
Yes.
21. My Lord has got 21. My learned friends at the end say there are 4 steps or 3 steps. Kindly come to 21. 21, step 1, independent audit, no problem. Anyway, Lordship has the power, there is no question of me saying no to it. See step 2. How does this work with greatest respect? Upon verification, this Honorable Court may consider directing completion of projects through NBCC, A, or a court-appointed administrator. When I am giving a proposal, when I am
In these proceedings, we are not going to consider all this.
A, B, my bail should be a hostage to that. Right or wrong, my bail should be a hostage to your Lordship directing NBCC. The next argument might as well be that till NBCC gives the Lordship the last flat, I should be in jail. Now, kindly give me a minute, please. Or a court-appointed administrator funded from the unencumbered assets of the group and its promoters. Is it ever possible for a builder to leave this expanse of land, find some other assets? I've spent 80 crores, 80% of the construction I've done. It's very nice to say, but it has to be practical, pragmatic. Then next sentence. Or from investors willing to secure their investment. Does your Lordship ever come across a case that investors will give more money to me to construct? Maybe ED, but this is a laughable proposal only intended to keep me in jail. So one proposal here is investors will invest more. Second proposal is that I will give some other assets and construct. Third is that NBCC will construct. All this can be decided. Nobody can run away from a Lordship's reach either in this matter or that matter. In a bail matter, with all these facts, how does it help liberty? Your Lordship can put me to all conditions. I beseech your Lordships to consider the liberty of the individual. I can't say more than this. I'm deeply obliged.
No, my lord,
Deeply obliged.
I'll reply to the contentions which are made by Lord Singhvi, my lord. First one, that he has participated in the investigation. 26 notices were given, 7 he appeared, 90 he did not appear. NPWs were issued. He was proclaimed offender proceedings were pending. He was arrested from a bar in, he was from Shangri-La Hotel, my lord. He tried to escape and he fell down, he got that injury. And he assaulted a government official during their proceedings. Third thing, my lord, this proposal on the direction passed by this court, my lord, during the partial working days, my lord, is by his son, Sikandar Singh. Now, my lord, he says 3 things. That whatever wrong has been done to us has been done by ED. By attaching our property. You remove the attachment and we will bring in the investor. And they will leverage on the proceeds of crime, my lord. They are attached by under a provision of law, my lord. Attachment confirmed. Fourth thing, my lord, most importantly, what have they stated in their proposal? We have only replied to what Dr. Singhvi was referring to at para 21 of my reply. Kindly at the second last para of this proposal. Page 14. My lord, on the first date of hearing, my lord, it was submitted on the bar that we will give this, give the possession of the flat within 3 months. In their own proposal says 15 to 18 months. My lord, they are empty shells. And my lord, one of the project, only 2% was completed. And in so far as, my lord, the attachment is concerned, my lord, attachment is, it does not create a bar that you cannot construct, but you can construct from your own money. You fund that project because that money which was supposed to be utilized for construction of these houses have been laundered and utilized by you for your own purposes. And, my lord, other promoter companies.
Today what they are asking for is these proceeds of life. Please allow me.
Lordship, add at this stage.
At this,
Yeah, after a few months after.
Lordship, add at this stage.
At this stage.
That's
We have said at this stage.
Deputy to file for a few months.
At this stage.
तो दोस्तों, आज माननीय सुप्रीम कोर्ट में हुई इस बड़ी बहस और फैसले पर आपकी राय क्या है? क्या आपको लगता है कि इतने बड़े वित्तीय मामलों में जमानत ना देना माननीय सुप्रीम कोर्ट का यह रुख बिल्कुल सही है? अपनी राय नीचे कमेंट्स बॉक्स में जरूर साझा करें। जय हिंद दोस्तों।